Hi, I'm Russell Hasan. Today I'm going to be talking to you about my book, A Law and Economics Approach to Litigation Costs. The subtitle of this book is The Proportionality Test for E-Discovery Law. This is the book. So I've worked in e-discovery in the law for quite some time, and I came across the proportionality doctrine. So what is the proportionality doctrine? Well, it's a doctrine based on a rule in the Federal Rules of Civil Procedure, which says that in e-discovery, the costs should bear a reasonable relation to the case and the needs of the case. So the reason why this rule was enacted is that e-discovery costs are incredibly expensive. By some accounts, they are by far the most expensive cost in a lawsuit, especially in complex federal litigation. So this rule was added to the Federal Rules of Civil Procedure so that the litigants, mainly the rich corporate defendants, would not have to spend so much money on their e-discovery costs. Right, because the rule says that if the cost is not in proportion to the needs of the case, then you don't actually need to spend the money, and there's no legal requirement that you spend that money. If that rule did not exist and you did not choose to do the e-discovery, which means that you, well, let me explain e-discovery. It's where in a case, typically the defendant has millions of emails and Word documents and PowerPoints and such. And so the plaintiff will issue a request for production, which says what documents they want. And then the defendant has to review all of their millions and millions and millions of documents to see which ones match what the plaintiff is looking for. And then if it's a match and you do not have attorney-client privilege, then the defendant has to give those documents to the plaintiff. And this procedure, especially reviewing millions and millions and millions of documents for each case, can cost, hundreds of thousands of dollars or millions of dollars. So this rule was added to the Federal Rules of Civil Procedure to say that if this cost is too expensive, you don't have to pay it. So I was looking at the proportionality doctrine, and I was like, okay, so what is proportional? What is proportionate to the needs of the case? What is the cost that it should cost? And I looked and I looked and I looked, and nowhere does it actually say what the cost should be. And I did research, I did my homework, and no one had ever actually given a precise mathematical formula for what the cost should actually be. So I took it upon myself to try to answer that question. And I went back to law and economics, which is the great movement in the law which ties law to economics, which I thought would be very useful for this. And I did some analysis, and I essentially invented a mathematical formula for what an e-discovery project should cost to answer, to answer the question of what it should cost and to add to the proportionality doctrine of the Federal Rules of Civil Procedure. Now, looking at this question, it then became clear to me that this answer also answered the broader question of, what should a lawsuit cost? What should you spend on a lawsuit? What should your litigation costs be? So I took my research and my mathematical formula, I packaged it into a paper, and I wrote it so that it's focused on the proportionality doctrine, but it also answers the broader question of what a lawsuit should cost. I made clear that I was giving it a rigorous theoretical justification in the law and economics movement, and that's this book. And I hope that if it's of interest to you, that you will take a look at it. Again, this is A Law and Economics Approach to Litigation Costs by Russell Hasan. And the book is available on Amazon, and it's something that I think every lawyer should read. And if you're going to be involved in a lawsuit, or especially if you're going to be involved in the e-discovery phase of a lawsuit, then I think that you should take a look at this book. Thank you.